Summary judgment can be difficult to grasp. It's important because many cases in your textbook are appellate rulings on summary judgments entered by trial courts. Summary judgment makes the court focus on legal questions, not factual disputes. If there are essential facts in dispute, summary judgment is not appropriate and there must be a trial. For example, suppose that Bob and Susan meet at a church pancake breakfast, chat about Bob's Ferrari, and end up signing an agreement that Susan can buy it at the extraordinarily low price of $30,000. Bob then refuses to honor the agreement, claiming he was drunk when he signed it. Susan, however, has 35 witnesses who swear that Bob was sober. Bob has only himself testifying that he was drunk. Susan moves for summary judgment. What's the ruling? Summary judgment is denied. The parties have a key factual dispute, whether Bob was drunk. It makes no difference how many witnesses are on each side. If there is some evidence on both sides of an essential fact question, a trial court must deny summary judgment. Suppose that Bob and Susan orally agree that she can buy the car for $30,000. Bob refuses to honor the deal and she sues him. Discovery indicates that Susan has 30 witnesses who will testify that the parties orally agreed to the deal. Bob has 5 witnesses who would testify that the parties never even orally agreed. Bob moves for summary judgment based on the statute of frauds provision of the Uniform Commercial Code. This kind of contract for the sale of goods over $500 must be in writing to be enforceable. The ruling on this? Summary judgment is granted. There is no need to decide which of the witnesses is telling the truth. Even if Susan's witnesses are convincing, she still loses. As a matter of law, the contract is unenforceable. During voir dire, the court's goal is to select an impartial panel. Each lawyer, by contrast, is striving to obtain the most favorable jury possible. Each potential juror is questioned to uncover any biases. Each side can claim any juror shows significant bias. Each lawyer can dismiss a limited number of jurors without stating a reason. In the end, 12 jurors and 2 alternates are selected. Our system of justice assumes that the best way to bring about the truth is for both sides to go at the various witnesses, enabling a neutral judge or jury to detect the truth. I'm sure you've seen movies where expert witnesses are called to the stand to testify. An expert is one of the few witnesses in court generally permitted to state an opinion. The lawyer who is called the specialist must first qualify her as an expert and then summarize the evidence upon which the witness is to give her opinion. Experts are common and often influential. Too influential, some people think. What's the danger in allowing experts to testify? Well, some believe that experts favor one side, and receipt of fees may compromise their integrity. Furthermore, it's the jury's job to decide factual issues, such as the nature of a contract, the reasonableness of a product design, or the intentions of a criminal defendant. An expert's credentials may so impress a jury that it abdicates its role. Suppose a plaintiff sues a defendant claiming that the defective design of a power saw caused him serious injury. At trial, the defendant's expert witness is an engineer who is acknowledged as the world's leading expert on power tool safety. He has written the leading manual on power saws and safety issues. He testifies that this saw was as safely designed as any in the world. May the jury still find for the plaintiff? Yes. The jury has to listen to the expert, but need not believe him. He's just another witness. The plaintiff always has the burden of proof, and he must convince the jury that his version of the case is correct. In a civil case, the proof needs to be by a preponderance of evidence, meaning at least slightly more likely to be true. In a criminal case, however, the proof required is much higher. It must be beyond a reasonable doubt. Rules of evidence means that lawyers are allowed to ask only questions that are relevant to the case. Try not to confuse whether a person can prove her case at trial with whether or not she has suffered a legal wrong and has a cause of action. For example, consider a simple oral contract in which Mark offers David $50 to shovel his driveway, and David accepts. There are no witnesses. David shovels Mark's driveway, but Mark refuses to pay. In considering whether Mark's obvious breach has violated David's rights under the contract, you may say no, because David can't prove there was a contract, it was not in writing, and there are no witnesses. But there's a difference between whether Mark violated David's contract rights, he has, and whether David can prove the terms of the contract at trial. Hearing evidence and finding facts is the job of trial courts. During opening arguments, a brief summary is given by each side of the facts that they hope to demonstrate. The plaintiff calls his or her witnesses, and then the defendant's side cross-examines them. After this, the defendant moves for a directed verdict, in which they ask the judge to decide that the plaintiff has no case worth proceeding with. In the defendant's case, opening arguments were presented earlier before the plaintiff gets to present his or her case. The defendant calls witnesses, then the plaintiff questions those witnesses, and closing arguments are made. The jury should evaluate the case based completely on the facts and come to a verdict. Sometimes this happens within an hour, sometimes it takes several weeks. Sometimes the vote is unanimous, other times they have to come to a majority decision. Sometimes when you think the trial is over, this just isn't the case. The loser might request a judgment notwithstanding the verdict, asking the judge to overturn the verdict on a legal technicality or on a claim that the jury ignored the evidence. If the judgment notwithstanding the verdict is denied, the losing side may request a new trial on the same claims. The recourse for the loser is to file an appeal, a request for a higher court to examine the facts. The appeals court may affirm the verdict, modify the award, reverse and remand, send it back to trial, or simply reverse the lower court's verdict. At any point, either side may offer to settle the case, even between the verdict and the beginning of an appeal. The process of litigation, with its potential for errors or biases, may influence the outcome of a dispute as strongly as the law itself. That is all the more reason to prevent disputes if possible, or to use alternative methods of dispute resolution.